quite as rapidly. We've heard this legislation the previous 2 years, and this is a third attempt. I think it's better than the prior two, and it's to fix a problem that we have here in Missouri. And the best way to explain the problem is I'll give you an example. Let's say I'm a resident in the state of Kansas, and I'm in an auto accident, and details are fuzzy. You know, maybe the police are doing a report, but they weren't there. There weren't many witnesses. Things are coming to light. You know, there's a lot of things involved. In the state of Kansas, the insurance company would perhaps come to their insurer, and they would say, "Now we're going to defend you with the reservation of rights," meaning we're going to defend you. But at the end of this defense, it's very possible that we find that we're not even that your policy limits may not apply. In other words, the other person may be totally at fault. There may be a third party that was at fault. It could have been a traffic device. A municipality was the cause of this accident. But we are going to afford you that defense. And so, you know, they would go forth. In Missouri, same situation. The insured, or whether the person normally would be a defendant, could, when his insurance company came and said, "Look, we're going to defend you. This could be months as this case goes on, or we're finding out facts to find if the policy actually applies," the person can say, "No, that's okay. You know, you're either in with me now or you're not." This has caused problems where it's created a lot of, it takes something that could be easy litigation, where that, as happens in most states that I'm aware of, there could be a state or two, I'm not aware of it, that allows this, but why Missouri is different is there was a case years ago where there was a bad player, and they caused a case to go to all the way up to the Supreme Court and determined that, well, no, the insurance company, you can't proceed on. You need to say right up front whether you're in or out. And it was that case, I think, was a particularly bad one to make a law on. You know, I think most of us would agree that you have a one-time situation doesn't always mean we need a law to fix that one-time situation. And I believe that that's what happened there. There was case law that came from a situation maybe that was kind of a bad egg, maybe an insurance company that wasn't handling a case the way they should have. Bottom line is, what this does is this gives these companies in Missouri the same opportunity. It doesn't say they get to sit on the fence. They still have the obligation to duty to defend their customer. What it does, though, is it just says that you have to, as the customer of the insurance company, you do have to accept the fact that they're going to defend, but that doesn't mean they're saying we're on the hook. You know, there's going to be, there's people that are going to talk about this that are a lot smarter than I, and I would probably recommend you save technical questions for them. There will be people in favor of it. I've got a couple of witnesses going to be here, and there's going to be people that are not in favor of this legislation. But I would be glad to answer maybe some more broad questions. But if you got technical issues with how this will impact certain statute, I'd recommend you wait until the witnesses come forward. And Mr. Chairman, with that, I'd be glad to answer any questions.
All right, does the committee have any questions for the sponsor? Just, I'm out of curiosity, not so much for you, the sponsor, but to get a gauge on time. How many, could you raise your hand if you plan on testifying for or against or for informational purposes on this bill? Okay, that's good. If there was like everybody, then I'd say, well, we're going to have to limit it, but I think we should be okay. We should be good. All right, well, bring your first witness in favor forward.
Okay, well, the first witness here is, he was unable to attend. I've got his witness appearance form. It's Ray McCarty on behalf of the Associated Industries of Missouri, and wanted me to read this into record. Associated Industries of Missouri, we support this bill. The bill allows an insurance company to agree to defend an insured with a reservation of rights. But if the liability is found to be excluded from coverage under the insurance policy, the insurance company is not liable for damages simply because they agreed to defend the insured subject to a reservation of rights. Thank you. And my witnesses then